The Judiciary Act of 1789. The Judiciary Act of 1789 was a United States federal statute adopted on September 24, 1789, in the first session of the First United States Congress. It established the federal judiciary of the United States. Article 3, Section 1 of the Constitution prescribed that the judicial power of the United States shall be vested in one Supreme Court and such inferior courts as Congress saw fit to establish. It made no provision for the composition or procedures of any of the courts, leaving this to Congress to decide. The existence of a separate federal judiciary had been controversial during the debates over the ratification of the Constitution. Anti-Federalists had denounced the judicial power as a potential instrument of national tyranny. Indeed, of the 10 amendments that eventually became the Bill of Rights, 5, the 4th through the 8th, dealt primarily with judicial proceedings. Even after ratification, some opponents of a strong judiciary urged that the federal court system be limited to a Supreme Court and perhaps local admiralty judges. The Congress, however, decided to establish a system of federal trial courts with broad jurisdiction, thereby creating an arm for enforcement of national laws within each state. This is the first Supreme Court of the United States appointed by George Washington, which the act gave him power to appoint six, and the six he chose was John Rutledge, William Cushing, James Wilson, John Blair, and James Iredell. The Supreme Court was given exclusive original jurisdiction over all civil actions between states or between a state and the United States, as well as over all suits and proceedings brought against ambassadors and other diplomatic personnel. An original but not exclusive jurisdiction over all other cases in which a state was a party and any cases brought by an ambassador. The court was given appellate jurisdiction over decisions of the federal circuit courts as well as decisions by state courts holding invalid any statute or treaty of the United States, or holding valid any state law or practice that was challenged as being inconsistent with the federal Constitution, treaties, or laws, or rejecting any claim made by a party under a provision of the federal Constitution, treaties, or laws. The Act also ratified or created 13 judicial courts within the 11 states that had then ratified the Constitution. North Carolina and Rhode Island were added as judicial courts in 1790, and other states as they were admitted to the Union. Each state comprised one district, except for Virginia and Massachusetts, each of which comprised two. Massachusetts was divided into the District of Maine and the District of Massachusetts. Virginia was divided into the District of Kentucky and the District of Virginia. This act established a circuit court and district court in each judicial district except in Maine, Kentucky, where the district courts exercised much of the jurisdiction of the circuit courts. The circuit courts, which comprised a district judge and initially two Supreme Court justices of riding circuit, had original jurisdiction over serious crimes and civil cases of at least $500, involving diversity jurisdiction or the United States as plaintiff in common law and equity. The circuit courts also had appellate jurisdiction over the district courts. The single judge district courts had jurisdiction primarily over admiralty cases, petty crimes, and suits by the United States for at least $100. Notably, the federal trial courts had not yet received original federal question jurisdiction. Other provisions. Congress authorized all people to either represent themselves or to be represented by another person. The act did not prohibit paying a representative to appear in court. Congress authorized persons who were sued by citizens of another state in the court of the plaintiff's home state to remove the lawsuit to the federal circuit court. The power of removal and the Supreme Court's power to review state court decisions where the federal law was at issue established that the federal judicial power would be superior to that of the states. The Act created the Office of Attorney General, whose primary responsibility was to represent the United States before the Supreme Court. The Act also created the United States Attorney and the United States Marshal for each judicial district. Tap, 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 case ended.